Welcome to EPG Pathashala. I am Dr. S. Samba, retired Deputy Director from the Central Leather Research Institute, Chennai. This module deals with information related legislation, particularly with copyright. Now let us look at copyright. This is one area which is of utmost importance to library and information science personnel, and also an area in which we will have to educate our users. What is copyright? Copyright and neighboring or related rights is a right of use given by the law to the creators of literary, dramatic, musical and artistic works, software and so on for a specified period of time. The creator of the original work gets exclusive rights to use it and to distribute it. Unauthorized use is also specified under copyright. The purpose of the copywork also does not matter. It need not necessarily, even a small jingle or even a slogan can be given copyright protection. Now what does it protect? It protects literary works, musical works, dramatic works, graphics such as photographs and even paintings, other artworks, audiovisual works, software, databases, sound recordings and TV programs. To name just a few, there are many more which are protected by copyright. These are the main categories. An important fact that should be noted is that ideas cannot be given copyright protection. Only the expression of such ideas. Ideas have to be fixed in a tangible medium, be it paper or a CD or a DVD or a computer hard drive, whatever it may be. Copyright protection is automatic. It comes into existence once the work is created. It need not be registered. However, for legal purposes, it is in the interest of the creator to register his work or to get the copyright protection. The copyright holder is generally the creator of the work. However, this can also vary, as in the case of patents. In what are called as common law countries, if the work is created within the scope of employment, then the copyright will be held by the employer. In civil law countries, the employee holds the copyright. In India, the works made in the course of an author's employment, the employer is the first owner of the copyright, whereas it may not be so in all the countries. Another concept you have to look at is joint authorship. In the case of joint authorship, both the creators or the number of creators who are created with are all co-owners of the copyright. Now let us look at some of the terminology and concepts associated with copyright. A derivative work adapts or modifies an existing work. The copyright may be given to the work independent of the original work, which has its own copyright. For such derivative works, protection is granted without prejudice to the copyright of the original. Permission, however, has to be obtained from the original author for creating a derivative work. The next thing we will be looking at is public domain. Public domain refers to the works that are not protected by copyright. It is the body of knowledge to which no one can have proprietary interest. This body of knowledge can be used by anyone. Another category we can look at is orphan works. Orphan works are works which are still under copyright, but whose copyright holder cannot be located. This may be due to several reasons. The name might be missing, or the copyright holder it may not be possible to trace the copyright holder, or the inheritor of the copyright holder may not be traceable. In such cases, these are referred to as orphan works. Copying of such works can be obtained by the competent authority, which I will be discussing later on under digitization activities. Now, everybody would have seen the copyright symbol. Everyone is aware of the copyright symbol, which is an encircled C. It was introduced in 1952 by the Universal Copyright Convention and is used for all works and creations except sound recordings, which is the encircled P. The other terminologies we should be aware of, which are very important, are licenses and agreements. A license is an agreement where the copyright owner retains the rights but allows a third party to use his work on specific terms or for a specific purpose or for a specific period of time or a specific region, and this is done on the payment of a fee. A compulsory license is granted by a competent authority. Now, why is a compulsory license granted? Some of the works may be withheld by the copyright owner from the public, in which case compulsory licenses can be applied for, and the copyright authority will grant compulsory licenses for the use of such works. This again can be used in the case of orphan works, which I mentioned earlier. When I mention use, it could be performance or broadcast also. Assignment. In assignment, the copyright is permanently transferred to another party on a contractual basis. Different transfers of rights may be given. The author may transfer the right of a book to be made into a play, or for staging the play, and so on. Talked about copyright. There are two rights involved in copyright. One is the economic right and the other is the moral right. Economic right is the right to copy, the right to issue copies, to rent or to lend it, to perform or display, or to make adaptations or translations of the work. These are exclusive rights. Moral rights give the creator of the work the right to be identified as the creator of the work, and no one has a right to destroy or degrade the work, because the right morally belongs to the creator. Even if economic rights are transferred, moral rights continue to belong to the author. Now, we talked about related rights or neighboring rights. These are rights granted to persons, protect persons other than the authors. These are rights of performers, broadcasters, etc. Rental rights, where a work may be rented for commercial purposes, and lending right, where the practice of libraries fall under lending rights. We have mentioned infringement earlier in the case of patents and trademarks and so on, but I would like to mention it again because it is a very important and oft debated topic as far as information people are concerned. Infringement refers to unauthorized use of works without permission of the copyright holder. The use, please note, does not fall under any one of the exceptions which I will be describing in detail a little later on. It could also refer to the violation of moral rights. Damages can be claimed by law by the copyright holder for infringement. Another development with which library and information science people should be aware of, the Creative Commons. Creative Commons is a non-profit organization that enables the sharing and use of creativity and knowledge through free legal tools. It provides the creator of a work ways to authorize specific uses of their work while retaining control over the others. Creative Commons licenses do not replace the regular copyright, but are used along with the regular copyright. Please remember, they do not replace the regular copyright. Another thing which we should look at is circumvention. The widespread use of digital and communication technologies has made it easy for downloading, storing, retrieving, dissemination and reproducing of works. To prevent unauthorized copying, technology protection measures and digital right management measures have been taken by the copyright holder through encryption technologies by a combination of hardware, software, etc. Circumvention of such technology is an offense and is illegal. It is mentioned in the Digital Millennium Copyright Act of the USA and in section 65A of the Indian Copyright Act. As in every other form of intellectual property, you have international treaties for copyright also, because copyright law is country specific and several international treaties have been entered into harmonized national laws, and the treaties outline broad standards for member countries. The earliest treaty is the Berne Convention. The Berne Convention for the Protection of Literary and Artistic Works of 1886 is the earliest treaty, copyright convention. 167 members including India are parties of the convention. It established three principles. The first is national treatment. Under national treatment, foreign authors are given the same rights and privileges as domestic authors. The second is independence of protection, that is, countries must give foreign works the same protection that it gives to works emanating from their own country. And thirdly, automatic protection, in that it is not necessary to register the copyright. The second convention is the Universal Copyright Convention, adopted in Geneva and developed by the UNESCO. It is an alternative to the Berne Convention. Then we have the Rome Convention. See, the Berne Convention was entered into when there were only media, there was no media but only printed works. So, the Rome Convention looks after the protection of performers, producers of phonograms and broadcasting organization, and it was accepted by the members of the WIPO in 1961. The Copyright Act of 1957 is fully compliant with the Rome Convention. Then the two latest conventions and treaties are the WCT and the WPPT. These together are known as the Internet Treaties. What is the WCT and the WPPT? They are treaties for providing protection in the digital environment. It requires countries to provide protection to MP3, to software and so on. Together they are known as the Internet Treaties. Okay. I have already mentioned about TRIPS. TRIPS lays down minimum standards for copyright protection for its member countries. But a treaty about which we should all be aware of, very much aware of, is the Marrakesh Treaty. This was adopted by the members of the WIPO in Morocco in June 2013. It is important because it provides copyright exceptions to improve access by print disabled persons to copyright works. Agreement requires provisions in national laws that permit reproduction, distribution and making available of published works in accessible formats such as large print, braille books, etc. An important provision in the treaty is for the cross-border exchange of accessible format of books. India has already included this provision in its Copyright Act. Now, let us come to the Indian scenario briefly. The Copyright Act of 1957 came into effect in January 1958 and has been amended several times, with the latest amendment being in 2012. The 2012 amendments make it compliant with the Internet Treaties about which I spoke earlier. It covers all the works, creative works which I have mentioned earlier. So, please go through the Copyright Act to find out. It also deals with infringement, about which I will be talking a little later, and in addition to what I have already mentioned about infringement, say that the following acts are also liable for punishment, such as making copies for sale or hire, distributing illegal copies for trade, so that it affects the economic interests of the owner. Please remember, no copying should affect the economic interests of the owner. And importing infringing copies into India and permitting public performance of the works. The copyright in India, the Copyright Board, a quasi-judicial body under the Ministry of Human Resources Development, was constituted in September 58 and is entrusted with the task of judging disputes pertaining to copyright and also in issuing compulsory licenses, about which we spoke about during Orphan Works and under the section on licenses. The term of copyright varies from country to country. Now, let us look at India. Copyright in the case of literary, dramatic, musical and artistic works are protected for a period of 60 years from the beginning of the calendar year next following the year in which the author dies. That is 60 years after the death of the author. In the case of films, sound recordings, posthumous publications and government publications, it is 60 years from the date of publication. In the case of photographs, it was amended in 2012 and the term of copyright has gone from 60 years from publication to 60 years from the death of the photographer. Normally, we will not think of copyright in the case of stamps, but stamps also come under the ambit of copyright. Though it is not specifically mentioned by name, it is section 28 of the Copyright Act is applicable for all government documents. So, only stamps which are older than 60 years are in the public domain. There are exceptions to copyright use. So, let us look at these exceptions. These are known as fair use. So, what is this? When does copyright infringement not take place? When can a work be copied? These are questions which has exercised the mind of the information personnel. Article 52 of the Copyright Act mentions this. Please go through Article 52 because you will need it, you will need to refer to it very frequently in the course of your activities. What does it say? In briefly, it says single copy for private, personal and non-commercial purposes for research and study can be made. It can be used for criticism or review of the work, making of copies or adaptations of a computer program by the lawful possessor of such a program, making of backup copies purely as a temporary protection against loss, use of work for the purpose of reporting current events in a newspaper, etc., and the use of the work for the purpose of a judicial proceeding. This is just in brief. Please go through the section. Also, the reading or recitation in public of an extract, the reproduction by a teacher or a pupil in the course of an instruction, and please note this carefully, the making of not more than 3 copies of a book by or under the direction of the person in charge of the public library for the use of the library if such a book is not available for sale in India. And the 2012 amendment with regard to fair use now covers all works except software, that is, it covers sound recordings and videos as well. So, if the library personnel is helping the teacher or the professor to make copies of songs and films for use in classrooms, it can be done so. There I mentioned there is punishment for infringement. Infringement is punishable under section 63 of the Indian Copyright Act. For the first term, it is imprisonment for a term which should not be less than 6 months, but which may extend to 3 years, and with fine, and which shall not be less than 50,000 rupees, but may be extended to 2 lakh rupees. The minimum punishment for infringement of copyright is imprisonment for 6 months and a fine of 50,000. That is the minimum. As it is a cognizable offence, any police officer not below the rank of a sub-inspector may, if it is satisfied that an offence in respect of the infringement of copyright is taking place, can seize without warrant all copies of the work and plates and all plates used for the purpose of making infringing copies. Regarding computer software, the Act specifically explains the right of the copyright holder, making it illegal to make or distribute copies of the copyrighted software without proper or specific authorization. Now, let us look at copyright in the library and information centers. This is discussed in the context of the activities which I am mentioning below. These are provision of copies, budgeting, creation of websites, online database access, digitization activities and transfer of copyright. Now, let us look at each one of them in detail. Provision of copies. The provision of copies is something which libraries have been doing for I do not know how long, for a long time. So, the purpose for which copies are provided determines infringement. Is it for research and study purposes only? Is it for in-house course materials? Is the screening done for the purpose of instruction and education? So, this is something that we have to be very much aware of before giving copies of the materials. Projects may be taken up which are sponsored by the industry. Then what do we do? So, all these are things which have to be looked at very carefully, both in the Copyright Act or can be discussed with people who have specialized in copyright, so that infringement does not take place and the organization in which we work are not involved in cases. Then I have talked about assignment of copyright. Many of the information personnel may be working in academic and research organization, whereby the scholars will be publishing their findings in scholarly periodicals. They have to assign copyright in such cases. For this purpose, they should be made aware of, the library information science persons should educate the research personnel about copyright assignment, what is it that they are entitled to, and also of Creative Commons, about Sherpa and Romeo project and so on, which is all given in the module, so that when transfer of copyright takes place, the person who is transferring the copyright is fully aware of what is being transferred. Now, we will come to transfer of copyright. In many of the information and science personnel may be working in academic or research establishments in which findings of the research are being published in scholarly publications. When such a thing takes place, copyright may be transferred to the publisher. The LISP will have to educate the person, will have to educate the research scholar on copyright assignments, on the transfer of copyright, so that they are fully aware of what they are transferring, and also educate them on Creative Commons, Sherpa and Romeo, on Creative Commons and Sherpa Romeo projects, about which I have discussed in the module and details of which are available on their website. So, this is an integral activity which of the library and information science personnel. I will be referring to this again when we talk about institutional repositories. Then inclusion of photographs. When a photograph is included in a text which is being brought out by the parent organization, copyright has to be obtained separately for those photographs. This is something which we should be aware of, and also the term of copyright. Access to e-journals. This is we will discuss in another module where e-journal access would have been discussed in detail, but copyright details and copyright access, especially in the case of downloading and printing, will have to be taken care of. This is also described briefly in your module. Sometimes we download independent articles for which we pay fees. So, copyright fees have to be budgeted for in our budget. All libraries create websites of their libraries, and in the websites links are given to other websites to facilitate access to information. However, we may inadvertently infringe copyright. So, it is essential that the library and information science personnel get copyright permission from the other websites before giving these links. And guidelines will also have to be drawn up when we have to give permission to other websites when they want to link to our website. So, this falls within the purview of the library and information science personnel. A major activity of most libraries is digitization. Essentially care has to be taken to ensure that the material that is being digitized is out of copyright, or that permission has to be obtained. The Digital Millennium Copyright Act of the USA allows no more than 3 copies to be made for preservation purposes. A similar provision exists under section 52(1) of the Indian Copyright Act. However, in cases where we have to get permission, we want to make multiple copies, it may not be possible for us to trace the owner of the copyright. All steps have to be taken to trace the owner, and clear and precise documentation has to be maintained of the steps taken to trace the owner of the copyright. This is very essential because it is a legal matter. To facilitate digitization of libraries, a new clause has been introduced in the 2012 Amendment Act, Copyright Amendment Act, to enable the storage of a digital copy of a work if the library possesses a non-digital version of it. So, please go through the 2012 amendments also. I have already mentioned about Orphan Works and compulsory licensing, and this will apply for digitization activities also. I am just mentioning, not describing, because it is still under discussion and a lot of the issue is still being considered. So, please look at the web for recent legal cases in the case of Google Books, Hathi Trust, and the directive of the European Court of Justice, which came out in September 2014 regarding digitization of works and getting copyright for such works. All the websites and the details are given in your module. The final thing that we will be looking at is institutional repositories. Most libraries are now setting up institutional repositories of their own work. In such cases, copyright has to be looked into, whether the publisher gives copyright for the whole work to be put on their institutional repositories or only an abstract of the work and so on. All this will have to be agreed upon when transfer of copyright takes place. Another matter of interest is copyleft. Copyleft is a general method for making a program or software free. The website is given in your module. Please go through it to see what is copyleft. Thank you.